All right, today we have Barry Dorans once again to give us some knowledge about some upcoming labor laws that took effect yesterday. My name is Chip Dodd. I'm with the EO Southeastern Virginia chapter, and I've been doing this webinar series with Barry because we go way back on a number of topics, and apparently this is kind of a fun webinar format where we get to banter a little bit. But Barry is from Wolcott Rivers and Gates. He is a absolute Jedi in anything related to labor law. And then when this PPP thing came up, he became the Jedi on that as well. So, and he's been willing to come and give us his knowledge on some, today especially, very important things that any employer needs to know that they should have been doing yesterday moving forward. And so, Barry, thank you so much for taking the time. I look forward to seeing your presentation.
So, Chip, again, I want to thank you for all the hard work you do in putting this together. And I want to thank everybody on the webinar with us. I know your time is valuable, and I'm going to try to run through things kind of quickly. I will quote from my mother, "Do you ever talk slowly?" So if I go too fast and you miss something, Chip will jump in and stop me. Let me start by saying Virginia used to be known as one of the most favorable places to be an employer. Basically, all the laws were in your favor. That has changed radically as of July 1st. It's not all doom and gloom, because I think we have a lot of strategies to deal with at least 4 of the changes. For the 5th change, you're going to see on the slide screen, I'm going to say, hey guys, do you have any ideas? I got nothing. You're going to hopefully tell us what we can do. And I want to start with Chip. There was a series of questions, and Chip sent one to me, and they said, what are you going to do with all these labor lawyers acting like ambulance chasers and harassing us when people leave? And I want to say I find that very upsetting and defamatory to the ambulance chasers. Because at least in an ambulance chaser, somebody got hurt. In this labor law, these people aren't hurt at all. They're just still trying to ring you for money like a pirate. So I call them more pirates than ambulance chasers.
Okay.
But without that, any more ado, let's go to the screen, which hopefully should show up.
I wasn't sure. I put that one poll question, is your HR team ready, with a percentage? That was one I came up with.
Yeah, let's do it. Let's go for it now.
Okay. So I'm going to launch this poll. And this is just to give us an idea. Was everybody as blindsided as I was, basically? Because I was thinking about the thing we're not going to talk about, as well as PPP. So I put a poll on the screen. We've got, I can't see the attendees at this point. We have like 20-something attendees. I want to know, how are you, basically, it started yesterday. Has your HR team already done everything necessary to be in compliance with the new laws that just changed in Virginia, that took effect? Everything from misclassification of employees, compensating people properly, how to notify people when they get pregnant of their rights, etc. So, so please take the time to just fill out that poll. It's your gut feeling. It's okay if you're like, what new laws? I have no idea. Chip said, attend this thing, and I'm learning today. But I'm really interested. I think Barry is too, to see how many people. And I'm going to give this one more minute, so I'm going to keep chattering for a second. But the other thing is, if, let's say, for example, something is happening in the Virginia Medicaid world, we've got a very robust trade association with VACSB, with VNPP, with Virginia Access. We have lobbyists, and they go, hey, guys, we need to do an action alert and send in your information and call your senator because this is BS and we shouldn't have to deal with this. I got nothing on this labor thing. This stuff went through the Virginia Assembly, and I haven't heard any entrepreneurs talking about it, any employers. I felt blindsided. I wanted to be up rattling cages at the General Assembly, telling them I don't want this. But either way, that's how. So, okay, so I'm going to end polling, and I'm going to show everybody, share results. So here are the results.
Wow.
30% had no idea. That was me a week ago, right? Until you told me, Barry, actually, I had no idea. 40% say they, I'm sorry, 29, another 30% or so say they're about 40% there. Nobody fails completely. They're good. And then 25% said 80%. So there are some people in the loop on this. This is really good. Probably your clients that you told with an email a couple weeks ago saying, hey, you guys might want to keep an eye on this. Okay, so that's pretty interesting. Maybe that'll help you frame your presentation.
That does. So I'm going to go through real quick. We'll get this back on. There we go. Those are some of the things I did. I told Chip I hate going through boring. Here's where I went to school. So here are the things we're going to talk about. Independent contractors. To me, that's the most important change we have, because if it hits you, it's going to hit you hard, and it could well put you out of business or put one of your competitors out of business. Next, employment at will. Again, dramatic change in Virginia law. Next, covenants not to compete. We're going to discuss with them. Pregnancy accommodations, and that's the one where I'm going to ask the group to say, do you guys have any suggestions? Because I got no strategy to deal with that. And then finally, retaliation. So let's start with another poll question, Chip. This is the one on independent contractors, and I'll babble as you put that up. So independent contractors, the question is going to be, what's the longest period that you've had an independent contractor that's worked primarily for your business, 30 days, 60 days, 90 days, 6 months, or more than a year? So independent contractors, what are they? They are people that you love to have do work for you. And the reason is, if they're an independent contractor, I, as the employer, don't have to deduct withholdings. I don't have to pay any unemployment tax. I don't have to include them in my workers' comp premiums. I don't have to pay any share of FICA. I don't pay any employee benefits, don't pay vacation, health insurance, co-pays, holidays, life insurance, retirement. I don't pay overtime, don't pay minimum wage. Great for me. Federal government hates it, state governments hate it because they don't collect the taxes. So let's see, do we have a poll answer yet?
I've only got 13 out of 35, so if everybody can just take a couple seconds and fill this out to the best of your knowledge. To answer Karen's question and anybody else in my company, sponsors do not count. They're foster care families, and they are not a 1099 independent contractor, so so that doesn't count. So I guess in the human services world, this is a clinician or somebody that goes out and does things for your customers, and they bill it. So you're able to bill Medicaid, and then you pay them as a 1099 because maybe they work for multiple companies. On the contractor side, maybe you put on siding on houses, or you do work for homeowners and you sub it out, but they're wearing your shirt. I think Verizon does that. Lowe's and Home Depot do that a lot, where they sub out their work. It's not really a Lowe's employee. It's a subcontractor. So okay, so we're up to 22 of 36. I guess I'll go ahead and end polling because everybody has voted, I guess. Okay, so here's the end. Let me share the results. So that's what we're looking at. Okay. 68% more than a year.
Wow.
You love that, don't you, Barry?
Yeah, I do. Okay.
That's money in the bank. You can,
money in the bank. So
let's secure a line of credit with that.
Yeah, no kidding. So let's go back and look. Basically, what the new law says as of yesterday, any individual who performs services for a person for money shall be presumed to be an employee of the person who paid it, unless it's proved that the individual is an independent contractor as determined by IRS guidelines. So I want to break that down. So what's a presumption? So a presumption comes in and says, if they sue you and they put on no evidence and you put on no evidence, they win. That's what a presumption means. So the court's going to start by saying, hey, that person, you're paying a person money, that's supposed to be an employee, unless you prove, and you're the one with the burden of proof to do that. Now, an important question that I don't know the answer to is, what do they mean when they say an individual? If they mean a person, which is what I think they mean, meaning a human, then any one of those people that you are paying, they're presumed to be your employee going forward.
So this would be, I guess, a sole proprietor?
A sole proprietor or anything. The individual, the question I have in my mind is, does an LLC count as a person? And that I just don't know.
So I would imagine there's some consultants out there that it's like Chip.LLC, and I'm going to come help you, whatever, run some numbers in your company and give you some guidance. You're paying me as a 1099, but I also work for 10 other companies.
Correct. But the question to me is do you get the benefit of the presumption when you have LLC at the end of the name? And that we just don't know. Okay. So I haven't given you the 20-factor test. It's a 20-factor test. And the reason why is this. I put up this little chart basically to show you that of the 20 questions, you could get 2 of them with a plus and 18 with a negative and still pass the test. Or you get 2 with a plus and 18 with a negative and fail the test. So they don't weight any of the questions, and they just say, we're going to look at it all and we'll make a determination, which we as lawyers hate because it doesn't give us any real guidance. So here's the primary factors that they look at. Does the company have the right to exercise the control, or has it exercised the control? So it's either of those two. If you either exercise the control or have the right to exercise control, that's probably going to be an employee. Does the company provide training? And you'd think, well, that's a good thing. And the answer is no. If you provide training, that's going to make it sound more like you're an employee. Do you have the right only to determine whether the goal was accomplished? And I think, Chip, you've talked about that there are some people you may hire as an independent contractor. Well, if your only control is to say, hey, if the customer's satisfied, then I'm satisfied, that could be more like an independent contractor. Financial control, and this is the one that's going to be tough for a lot of people. Does the person have a significant investment in tools to do the work? And again, calling on Jeff Foxworthy, you may be an independent contractor. That is to say, I've spent tens of thousands of dollars buying all sorts of equipment, and now I'm a plumber. I'm probably an independent contractor. Most of the people we see nowadays in the IT world have spent $0 on training. So that's going to be a tough one.
So I guess in my scenario with a clinician, if the company provides them a laptop, a cell phone reimbursement, and they're claiming them as a 1099, that starts looking fishy because a contractor would come with their own laptop.
Yeah, but even then, is it a significant investment? It's a laptop. It's $1,000. What
Right.
they're really thinking traditionally was the guy that did the siding on your house. He has a truck. He has a bender. He has all sorts of other tools and equipment. That person doesn't have any of that.
Okay.
The next, anytime, just jump in. The next question they ask is, can that person have others do the work and make a profit? In other words, if you've hired a clinician, they can't have somebody else do the work for them, correct? It's that person who's supposed to be doing the work.
Yeah, usually you would hire the clinician because they have the credentials to actually provide the Medicaid billable service, and the agency that's contracted with them would need to do the background checks and things like that to make them allowed. So they, by default, cannot sub it out without the HR department knowing about it.
Yeah, so that's an issue for you because now it looks like you're hiring a person, not a company. And that's the distinction you're always looking at.
Gotcha.
Can the person make any profit? And the answer is no, they can't. They're only going to get paid basically hourly for what they do. Whereas if they said, well, look, I could sub this work out and make a delta, that sounds more like a company. Does the person get an hourly rate? Obviously, that's more like an employee. And the relationship, is the relationship expected to be of long duration or continue to be terminated by either side? And that's when we looked at, gosh, over a year, yeah, you're going to be very hard pressed saying that's not an employee, because that's what employees do. They work for a long time. In contrast, oftentimes you may hire an IT company to come in and say, hey, could you configure something for us or do a security analysis for us? And it's a month or two and they're stopped. If you have somebody doing it for a year or so, that's going to be awfully tough.
Okay,
The
so
last
one
one,
other,
but
let me just jump in on that real quick, because you haven't touched on it, but I think it's important for employers to make a differentiation. In my world, right, I'm a human services provider. I don't do tech.
okay.
But if I hire either somebody or a company to come do tech, and it's here and there, and maybe even have an ongoing relationship, just come mess with the server and make that thing work properly. Since I don't do tech, it's a little bit easier to say they're a contractor. But if I'm hiring a clinician, when I also do that type of work, I do human services, I bill Medicaid, but I'm also hiring this clinician that also I'm billing Medicaid on their behalf. It's harder to differentiate because they're in my field. Does that make it more smell like an employee than a contractor?
Yeah, in fact, that's actually a death knell for you. That's going to be
Death knell.
that's going to be the nail in the coffin. And the example I gave is if I hire an IT person to oversee my company servers, but I don't do IT, perfectly fine. If I'm an IT company and I'm hiring people to perform IT services, the court's going to say that's your employee because that's your business.
That's my business. So, and so a lot of EO members are contractors, right? We do residential commercial property. So I'm a general contractor. I do a lot of stuff, but sometimes I want to sub it out because I don't want to do that electrical. I don't want to install that door, but I could do it with my employees if I wanted to. So
again, this is the part that we hate. It's 20 factors and we look at all of them. If you hired that plumber on 3 jobs and then didn't deal with it again over the course of the year, you're probably going to be okay. But if in all your jobs you're doing plumbing and you have that same guy doing that work, A, he's going to get the presumption, and B, you're probably going to get crushed. And so
and if I'm the only place they're doing work because I've got so much, I got 25 houses I'm flipping and they only do plumbing for me, then.
Yeah, and again, that's the same thing when we say is it a long time. If you've been doing 2 or 3 months and then 2 and 3 months, 2 and 3 months, that's one thing. But if it's for a year, bad news. Okay. So other factors they look at, and that goes to exactly what you're talking about, which is what they call the economic reality test. If that individual receives the vast majority of your compensation from one company, that tends to lead to an employment relationship. And again, I could go back to the plumber that comes in and does my stuff, comes to my house once or twice a year. If I cut him off, he loses nothing. On the other hand, if that was what he did all the time and he's working for me for the years, doing rehabs on every house I do, he's going to tend to be my employee. So what do they have the right to do? They have the right to sue me for wages and salary. Okay, that's not that bad. They have the right to sue me for benefits. which is the cost of insurance maybe, and retirement maybe, if I offered those, that's still not that bad. They have the right to sue me for the expenses that would have been covered by insurance. And that's the thing that have us lawyers jumping up and down and saying, are you serious? So for example, you have an independent contractor, he gets sick, he goes to the hospital, he didn't have insurance, and boom, he gets hit with a $50,000 bill. He can sue you saying, look, if I worked for you, that would have been covered by insurance. You owe me that. The one I worried about today is a lot of companies have a group life insurance benefit. If somebody dies and they were your 1099, does the widow or widower have a right to sue you and say, well, look, if he'd been an employee, he would have been covered by your life insurance. I want the benefit that should have been. The next part, this part, I think we've seen some questions about this already. Can they bring a claim for minimum wage and overtime? Oh, yes, they can. On the 1099, I don't track their hours. But now I'm going to have to, because if they're an employee, they're entitled to overtime. I have to track and make sure what they're doing.
So if they tracked their hours well, and the employer that is using them as a 1099 is not tracking because they're 1099, then they have the evidence, and the
Correct.
employer does not.
Correct. And the law says you are required to have that evidence, and since you don't, they're going to hold that against you. And the last couple of these we've had, the employee said I was working at least 65 hours a week. We fortunately had the records, and it was more like 45 hours a week. So believe me, their records are not the ones you want to rely on.
Okay, so we did have a question come through, and it's something you haven't touched on, but it was one of my questions I fired at you before you got here.
Okay.
So there are companies both on the human services side that are big publicly traded companies, and they just have a Virginia division. There's also companies that are based out of Virginia that do work in multiple states. So one of the questions is, does it matter where the company is incorporated regarding how they need to incorporate these laws into their practices?
Fantastic question, and I actually know the answer, mostly.
Maybe, right?
Mostly. It's where the employee does the services for sure. So in other words, if they're doing services in Virginia, they're going to be covered by this Virginia law, whether you're anywhere else. The reason we know that now is because we paid attention to this telework business, is that a lot of people are saying, look, I'm letting somebody telework from North Carolina. Well, if they work for me and I'm in Virginia and all my work is in Virginia, but they're doing transcribing or whatever it is, typing in North Carolina, I have to comply with North Carolina law. And I actually have to withhold North Carolina wage tax withholdings because they're a North Carolina employee. So regardless of where the employer is located, if the services are performed in Virginia, Virginia law is going to apply. Now, another question was asked, Chip, that you sent, which what about if during the day they spend part of the day in Virginia, part of the day in Maryland, and part of the day in North Carolina? Yeah, I got no idea.
Okay.
We know from baseball players that when they play in one city, they pay taxes in that city, and then when they play in the next city, they pay taxes in that city. And but those numbers are so huge, that's why.
Okay. So you're bringing up a really good point. Okay, so it's or another good question, I guess. So it's the physical location of the human being
who's doing the services. So in other words,
services.
If I got up and we had employees that got up every morning in North Carolina, drove to Virginia Beach, where our office is, and did work, Virginia law applies.
Virginia law.
Okay. But now they're telecommuting, they're in North Carolina. North Carolina's going to apply.
Okay, so, but as you know, because of the thing we're not going to talk about, telework is basically all of us, for people who work at home, we now have a global workforce. And me and you've talked about it. Don't even try to hire somebody in another country, because now you're dealing with labor laws in another country. Don't even try and go through a company. But let's say my friend that asked this question on here does software, and what if he wants to get a software developer from California? His HR department now needs to know California law for that remote worker. Precisely.
And while I am going to say some bad things about Virginia law, and I'm going to ask you to get your legislators to try to change it back, we're still not as bad as California.
Okay.
So you definitely have to comply with California law.
Okay. Because people on this webinar are primarily in Virginia, how bad is North Carolina and the people that are right near us? Are these states terrible states? I mean, relative to now Virginia?
So Virginia was great. So where it was is basically California, and California was the worst by far and probably still is. New Jersey was trying to put in a rush to get to number one. It didn't, but it's still pretty close. North Carolina was not as great as Virginia. Virginia's now gone probably the top 3 or 4 or 5 bad states to be. So North Carolina's not going to be as bad as us in general.
Okay, so one other quick one, then we'll move on. I'm sorry. This one blindsided me. I had no idea we were going to go down this rabbit hole, but I'm glad we're doing it. So for companies who do not have a robust HR department, if we're using remote workers, keep it in Virginia. That keeps it simple. Is that a fair statement?
Yep.
That way I only have to know one set of labor laws. And then if you want to get somebody outside the country, go through a company because you don't have to deal with it. But
Exactly.
the minute you go out, if you're using W-2 employees, not contractors, right? You're not using Fiverr. That's different.
Right.
You're hiring somebody remote. Unless you have a robust department and you're going to learn the labor laws of other states, keep it in Virginia.
Well, unfortunately, I have to tell you, you have to comply with whatever that state law is. The answer is you got to hope it's not worse than Virginia.
Okay. All right. I'll let it go. Thank you so much.
Cool. Anytime. So strategies, and that's one of the purposes we wanted to do this, is not to say, hey, here's doom and gloom. What are the strategies? So to me, this one's pretty straightforward. I want to analyze my workforce. And by workforce, I mean 1099s and employees. And let's say I have 3 or 4 1099s that are doing a similar service. Can I get them to form a group? Because if I get them to form a group and divide the pay among them, even if they're not an entity, I'm going to be in pretty good shape saying they're not my employee. Because I don't know who's doing what on what day. I don't have any control over that. That's among them. They have the right to get profits, loss, that stuff. Number 2, not as good, but not work. Can I convince any of these people to form an entity, an LLC, and obtain a business license? Now, it's still going to go through the factors and tests, and I may still lose, but I don't have the benefit of the presumption, or maybe not have the benefit of the presumption, or they don't have the benefit, because they're not an individual, perhaps. What about doing this? And this has come up already. There are a lot of employers that say, look, I'd love to have these people be my employees, but they don't want to be. Well, can I make an offer to them in writing, let them refuse it, and then have that documented and say, hey, look, you come and sued me. I tried to bring you in as an employee. I tried to give you all these benefits, but you said no, you wanted more independence and whatever it is. I think that would be very strong evidence. It wouldn't sell the day maybe, but it'd be very strong.
At least you tried. It shows your intent was to comply.
But not only was my intent to comply, that they didn't believe they were an employee. Because remember, they're the ones that are going to sue me and say, Chip, I wanted to be an employee. You wouldn't let me be an employee, and you owe me all this money. And Chip's going to say, yeah, I tried to make you an employee. You wanted to have more independence. And again, it's all going to get down to independence.
Or they didn't want to pay taxes.
That's exactly why, but that's why the government wants to make you make them an employee.
Yeah, so that's the other thing to clarify here. Both sides financially win if it's a 1099, unless you need things like benefits and holiday and all of that. So the potential employee that's a 1099, they sometimes want to stay 1099 because they like the additional income and the flexibility. And my understanding is both sides are avoiding taxes. So if the employer side saying, hey, we're cleaning up our books, we need to move you to W-2, and that person still doesn't want to, you're saying just document that and it might help.
Yeah, there are going to be people that say, no, I don't want to because of it. You point out, not just the taxes, but independence. I'm sick and tired of corporate life. I don't want to live by your handbook. I want to be an independent contractor.
Right.
How about number 4, which is try to have a written agreement, and this has always been a good practice, to say, look, you do whatever you want to do. All I care about is the end result. Without that, you're definitely going to lose. With that, and if in fact you follow that, you might have a shot at it. What about coming up with a compensation agreement that allows the independent contractor to make a profit? If you're paying them $20 an hour or $15 an hour, that's an awfully hard sell to say this is an independent contractor. He's got no ability to make any profit. Finally, there are some people that you're just not going to be able to put into any other box. Unfortunately, you're going to have to put them in the employee box. So those are the strategies that we're looking at.
Let me clarify just one thing real quick, and this isn't too big of a rabbit hole.
No.
Let's just unpack the ability to make a profit. So if I'm billing, let's say I'm a consultant and I'm billing $15 an hour, that's like what most people now are advocating for as a minimum wage.
Right.
And so it's like, whoa, like that's not profit. That's like you're making a what the government would think is a minimum wage. But if I was charging $100 an hour, then my labor part of that might be $40 an hour, which means the 60's profit to help me pay for my car. Or that.
So great question, and no, I've misled you. What I mean to say is, if I do a task and the amount of money I can make from that task minus my hourly rate could lead me to make a profit, that's a profit. So for example, if I'm an employee, it's not uncommon to say, I'm going to pay you whatever it is, say $60,000 a year. I make the same 60 no matter what I do as long as I work the whole year. If I am a subcontractor to you and you say, look, Barry, for every case you handle, I'll give you $100. And that leads me to be able to make more money if I can handle them expeditiously or if I can subcontract them out, then that would be a profit. I have a profit and loss like a company would.
I see what you're
as
saying.
opposed
So
to an individual.
if it's tit for tat, meaning every hour I bill, I get X, then I can't beat that by being efficient.
Correct.
Or outsourcing, et cetera. But if it's by project, then I can be efficient and I'm profitable.
It could be. Then again, that's just one of the factors, but to me, that's one I would definitely want to use.
Okay, good. Thanks.
Throw the slide up here. I don't think this will impact a lot of people. The construction people have gone crazy about it. Again, I think there's a pretty simple strategy to deal with. So what it says is for construction contracts, other than single family homes, if it's over 500,000, the general contractor, and I admit this does get crazy, is criminally liable, meaning they can put you in jail, and civilly liable, meaning you have to pay money if you knew or should have known that your subcontractor wasn't paying its employees all their wages due. And that applies to all lower tiers. That applies to wages under the Fair Labor Standards Act. So it could potentially deal with one of these misclassification issues that you've subbed out the drywall to somebody, and that guy, instead of making him an employee, has called him a subcontractor. The employees can bring a class action. To me, this is pretty straightforward. Why don't you just get a certification from each sub every time you give them a payment that they paid every one of their employees with each draw request, and post a notice at the job site, hey, if you're not being paid, here's the person at my group to contact in writing or by email. And basically you can say, look, I didn't know, I shouldn't have known, leave me alone. Not 100%.
Obviously in the contracting world, there are some workers that are documented and some that are not. Does it matter?
Right. If they're not being paid, it comes back to if you knew or should have known.
But that's what I mean. It doesn't matter if they're undocumented.
No, it doesn't matter at all.
Doesn't matter. Okay, that's what I figured is in the United States, not just Virginia, if you work and you are in this country, you deserve the same rights and privileges as a citizen.
Correct.
There's no difference, right? Okay.
So employment at will, and this is the biggest change that we've had, and I only use this as the second topic, not the first, because the change, while it's important, is not going to burn you as badly, hopefully, as the first one we went through. Employment at will. Can I fire somebody for a silly cause? The answer is yes. So in other words, if I come in, Chip, and I bring in 3 employees, say everybody draw a card from the deck, lowest card gets fired, perfectly legitimate. Fire without cause, up until a couple of days ago, yes. Today, no more. So one of the questions that always comes up is, should you give a written reason to the employee of why you're separating from employment? And if so, who do you send it to? And so the example I'm giving here is Cynthia. There was a write-up of this employee, Cynthia. She led a unit which caused significant gaps in their strategic plans and financial performance, and her team met their cash goals but were off on some other financial targets. She sued and said that was defamation. She covered a jury verdict of $1.5 million in compensatory damages and $2 million in punitive damages. So for years, we in the employment side have been saying, you should give a written reason, but be very careful about who you do it to and don't tell anybody else in the company. Now that's going to start to change. Under this new law, you're going to want to give that employee something in writing. So let's again give a little contrast why we care. Under federal law, it's always been that you can't discriminate if you have more than 15 or more employees, but federal court was not a great place for lawyers to go for a variety of reasons. Under the Virginia law, they get to go in state court, which is a much better place for them to be. They have a guarantee of a jury trial. And by the way, you're not going to get a jury of your peers. It's going to be a jury drawn from a bigger pool, not just employers. There's no cap on damages, and they get attorney's fees on top of any recovery. All those things, bad things.
And the administrative exhaustion.
Okay.
Isn't that just means like if there was a complaint with the Department of Labor, then there's a Department of Labor function that basically sorts it out and decides employer right or is the employee right and damages. But now it actually bypasses that and goes to court.
Yeah, so it turns out under the federal law, you had to file a complaint with the EEOC, and the EEOC would have to do an investigation and then make a determination. And that typically took anywhere from a year to 18 months, by which time the employee doesn't care anymore and they're over it. That's not going to be the case under the state law. They have to file a complaint, but they can go ahead and file suit right away. So that's going to be a concern. So this is the thing, again, when I talked about ambulance chasers, this is going to be pirates. There are already lawyers that we've heard of that said, anytime anybody gets fired, I'm sending off a demand letter. And so I think that some of us are going to run that risk that every time you discharge somebody, you're going to get a demand letter. I have other clients, I don't know if any of you had this in the Fair Housing Act, where They just bring a demand letter saying, I couldn't access your website and my person's disabled, give me money. And I think you're going to see the same type of thing. I don't know if anybody's received them yet. I know in the past, we would get them pretty regularly, but we just basically ignored them because they had no rights in Virginia law to do anything about it. Now it's completely changed. And so for some people, it's going to be a cost of doing business, that every time they let somebody go, they say, hey, they're going to go to a lawyer. I'm going to have to pay somebody some money to move on. And I point out, and that was just on the slide, for a little while, people would call me and say, look, I've been fired. Would you help me? I got out of that hundreds of years ago, but they would call and say stuff like, you know, they caught me stealing and they fired me for stealing, but that's not really why they fired me. And there's not, well, I'm serious, and you laugh, but nobody ever thinks they were fired because it was their fault. It's extremely rare that that happens. And so as soon as you fire somebody, they're going to go somewhere and say something. And so when I say fire, that's employers with 15 or more, they get to sue you for anything you do, any adverse action. You didn't give me a promotion, you reduced my pay, you changed my schedule, you put me on a performance plan. They have a right to sue you and say you've discriminated against me. You refused to allow me to work from home. Again, discrimination claim. Employers with 14 or less employees, they can only sue you for being fired. So I want to go over a couple
things. And I put this in my barrage of questions.
Sure.
Probably companies out there say, I'm insured for this, right? Like I don't have to pay the employee. My insurance company is going to hire a lawyer and they're going to maybe settle and my rates are going to go up, right?
Fantastic question. So generally speaking, your insurance does not cover this. There is an insurance practices liability insurance you can get, EP insurance sometimes called, or employer practices. Typically those policies have a fairly low value. 50,000 is not uncommon. They also have what they call a sharing component. That is to say, they'll cover 50,000, and maybe that means that of the first 50,000, they cover half, and you cover the other half. The biggest thing is they don't pay any money towards settlement, generally speaking. So they cover the cost of defense. So you're right that if you have insurance and they cover the cost of defense, that's great. Typically, though, it's on a proration, so you're going to have to pick up half. And we have a couple of those going on now where people have brought claims that are really basically frivolous. So by having that insurance, the employer has saved about 50% of what it would otherwise have to spend.
So not to go down an insurance rabbit hole, I know it's not your wheelhouse, but I guess, is it safe to assume that if I currently have employment practices insurance, they're probably rerunning some actuarials now?
I am certain that when you go back next time, they're going to revisit what they're going to have to charge you if this works out. Now, again, if it works out the way I think it's going to work out, I want you all to contact your legislators and say, guys, you got to change the rules. You've now tilted it so completely unfair that it's ridiculous. And let me go to this one next.
Okay.
These are just the things that you can sue about. And here are all the new ones. Pregnancy, discrimination based on pregnancy or related medical conditions, on hairstyle. If you fired somebody or didn't give a promotion because of the hairstyle or texture or tape or braids, sexual orientation and gender identity are now included in these protected classes. And so one of the concerns I have is that if somebody gets fired, all they have to do is say there's somebody else that meets any of these criteria that didn't get treated the same way, and they're going to bring a claim against you, which to me is crazy, but they're going to do.
And historically, let's say in a sexual harassment type thing, I come to my employer, my HR department, and say, hey, that person's hitting on me. I don't appreciate it. The employer, HR, had the ability to sort it out, make sure it doesn't happen again, bygones. So if hairstyle, right, I've got short hair and I'm going to say I didn't get the promotion because I got short hair and everybody with long hair gets promotions. Does the HR department have an opportunity to sort that out, or can I just go sue based on my short hair?
You can basically, well, actually, you can't sue on your short hair, but a person with long hair could sue, saying that, hey, that's historically associated with people who are African American, and you treated me improperly because of that. And yeah, you're right. There's no, the process that you used to have doesn't really apply anymore. They just go straight to court, or send you a demand letter, give me money. So that's a concern for us.
Let's take it to the other extreme.
Okay, good.
I'm trying to think of a traditional suit and tie professional thing that's not an attorney, because I don't want to pick on you. Let's talk about bankers.
Okay.
So all of a sudden, a banker that normally wears a nice suit and tie and they go out and they meet with very professional customers, all of a sudden starts growing out dreadlocks, regardless of, well, it could be me, right? My hair would grow if I would let it. So all of a sudden, a banker's walking around with dreadlocks, and Bank of America, because I'm going to pick on them because I don't like them, So they fire this person. Like, look, bankers don't have dreadlocks. Sorry, you're running off all of our customers. So that's an extreme. If they had a company policy that said all bankers can't have dreadlocks, would that be okay?
No, that would be a violation.
That'd be a violation.
Yeah.
So they just can't do anything. Everybody just grow their hair out no matter how unprofessional it looks. If I'm a cook, I lean forward, my hair's in the food. I mean, at some point, is there any threshold to where?
Right now, it's wide open. It's up to a jury to make a determination. But again, to me, that's not the biggest concern. The biggest concern is when you went through this list, the first, whatever, 5 or 6 things, you knew them when you hired those people. And you'll know them when you fired them. Again, I've been doing this a long time. I don't see people fired because of their race, because we figured out their race when we hired them. And most of the smaller companies, I know who that person is, their color, their religion, their national origin, their sex. I knew all that when I hired you. The concern is the employee's gonna say, that's why you hired me. Oh, it's because I have dreadlocks. And you're gonna say, no, it's because I caught you stealing. And they're gonna go, no, it was because it was dreadlocks. And they get to go to a jury to figure that out. And the next slide's the one I think that should scare you the most, because it terrifies me.
Because the other one wasn't scary.
It is. Yeah, this one's going to scare you. So so you fire somebody, Chip, and they sue you and say, Chip fired me because of, what's the limit on number of things they can say you fired them because of? Would it be 1? Would it be 2? Would it be 3? And the answer is unlimited. So they can go back to this and say, Chip fired me because of my race. I stole something and he fired me, but it was because I was black. And Chip would say, well, there's 3 white people I fired, therefore, for doing the same thing. Okay, well, it's because of my religion then. I am Presbyterian. Then Chip has to go through and find 3 other people of different religions and say, I fired them as well. Well, it was because of my national origin. And then you got to go through every single time they come up with something and try to find somebody who you treated the same way. Or they try to find somebody treated different. Well, there's a woman that you didn't do that same thing to. There was somebody who wasn't pregnant. There was somebody who didn't. And you're going to have to defend yourself on each one.
So the problem is, if the ambulance chasing attorneys find out that not many people have dreadlocks, they just skip the first ones, just get to the dreadlocks because Chip can't find 3 employees with dreadlocks. I'm done.
That's exactly right.
That's
there weren't people you treated differently. And so this is the slide that I'm pointing out to you. They don't have to come in and show you that somebody walked in and said, I fired you because of dreadlocks. All they have to show is, hey, there are people of some other classification that did something similar and you didn't fire. And that's a real concern for most employers, because you try to treat people as individuals and somebody's going to come in, they're a great employee, they show up late 2 days in a week, you're not firing them. Somebody else in the first 30 days, they've shown up late 3 times, you let them go, then they just fire you and they'll just click, 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 saying you fired me because of all these bad reasons, and you don't have to defend each and every single one. To me, they should have a limit and say, come up with 2.
Pick 2.
But it can't be 7 different things that are screaming against.
Okay, so there's things we can control and there's things we can't. And I can't control that they can go right down the list. But when I'm guiding my HR department based on this discussion, I'm going to guide them to say, guys, across the board, we're going to have reasons we fire people, and you do not fire anybody unless you follow this specific protocol. Because I can't control dreadlocks. I can't do that. But I could say, if we're going to fire somebody because they no-called, no-showed 2 times, then it's always 2 times. There's never a third. There's never the first.
Correct. So what I've done is, and we're skipping, but we'll catch up to it.
Okay.
Under B, under this slide, make our HR decisions robatic. So basically stay in your policy manual. If you're late 3 times in a quarter, in the old days we used to say frequently, it's automatic termination. And the good news about that is you say, well, look, here's what it is. You missed this. The thing I don't like is a lot of people say things like, we'll consider, I use promotion or tuition reimbursement. They use the kind of, we'll consider your application. If you have anything like that in your manual, you need to go through, to me, and start putting actual criteria. So for example, if you want to be considered for promotion, you have to have a grade of X for this many times on prior performance reviews, no negative write-ups within the last year. Spell all that out, because the more you can show, it's just, hey, I went through a chart, I checked the boxes, and this is what happened. There you go.
There you go.
So I'm going to go back.
Nothing like at the owner's discretion.
Oh my God.
I knew I'd get that reaction from you, yes.
So the most aggressive, and I want to give you options, the most aggressive strategy, and some people are suggesting that you could make new employees sign arbitration agreements go to existing employees and say, look, I'll give you a bonus if you sign an arbitration agreement. That at least keeps you out of them bringing you to a jury trial, which is where you do not want to be. A moderate one, and I don't know if this would work, but at least I'd think about it, is have an employment agreement that says if they bring a claim against you and they fail and you win, they have to pay your attorney's fees. Because the way it's currently written, if they sue you and recover, they get their attorney's fees. If they sue you and they lose, they don't get your attorney's fees, but you still have to pay your attorney's fees. So they have no, what we would used to call skin in the game. Conservative, and that's, some people say this, just do a slower to hire, slower to fire, try to do a better job screening. Oh, that's difficult. Some employees, as you know, some of the bigger companies have been doing this for years, a severance agreement for every employee. Hey, you're on the way out. Here's going to be a check if you sign this agreement releasing all those claims.
Okay, so got 2 questions for you. This is
Good.
good stuff. In many EO trainings, the old days before we turned into California, it was hire slow, fire fast. Like, get them, if they come in the first week and they're the wrong match, get them out quick. Primarily that was because go and make the decision now because you're going to make it later, and you want to get them off the unemployment thing where the unemployment goes to the previous employer. So is there anything different about that first month or so?
So I'm fine with that, but I would do it quicker than then. Obviously, 2 or 3 weeks, the sooner the better.
Okay.
But what I think what we're really saying is, and we'll do this in another slide, there are people that violate everything you, if you gave them a list of here's things not to do, they're going to work their way through one by one by one by one. And so sometimes you say, look, if they've been there 6 months and they're starting to go downhill, don't jump at infraction number 6. Give them a little more rope, let them do another couple more things wrong, and then fire them then. But I agree with you. If you decide within a week or 2 they're not working, or 3, you should move for that.
Okay, another one real quick. In the past when we have talked, before Virginia changed, you've said, I believe that arbitration agreements were not the ideal way because there was some nuancy stuff that it's actually better. But now you're saying because of these laws, we might want to go down the arbitration route. It's better than this federal court thing.
Correct. So what's happened is if it's a business-to-business transaction and a contract, I don't like arbitration. It's expensive and it's time-consuming. It's not very helpful. Here, the question is, I don't want to go in front of a jury where there's going to be a group of people, none of whom are going to be employers. Some of them would be employees who got fired. And as we looked at the slide I gave you, this woman, Cynthia, got a jury verdict for $3.5 million. And you're sitting there, what could they have possibly paid her a year to justify a jury hitting these people for $3.5 million? And the answer is they couldn't possibly have been paying her whatever that would have been, $300,000 or $400,000 a year. Yeah. You don't want somebody to unload on you. And an arbitration agreement, you're thinking, hey, there's a cool arbitrator. If he thinks I've made a mistake, I'll pay her a year's worth of wages and be done with it. I don't want to have a jury just unload on me. And
you're allowed to make that a requirement before I offer you a job.
So that's a good question. Kind of. I mean, there are certain employers that have said that. You can't, the question is whether you'll be able to fire somebody for not signing it. Probably not. Could you make that a condition going forward? Probably so. I would love to, and that's why I put on to me if you were going to do it, offer some sort of signing bonus or say, look, I'll let you come in as a regular employee, but I'll pay you $10 an hour. If you sign this agreement, it's 11 or 12, just in case you have to go and defend, hey, there was consideration for this agreement.
Okay, so for both that as well as a severance agreement, I'm just, not that I'm trying to like promote going to you or somebody like you, but this is probably not something people like me should just Google and take it off the internet and put it into place, right?
So my favorite is when employers Google non-competition agreements because they never get those right.
Yeah.
And release agreements, to be honest with you, if it's not dealing with age, you could probably actually draft your own and it would probably fly. I wouldn't suggest you do it, but you probably could make it work. Non-competition agreements, you'd never get it right. Arbitration agreements, extremely unlikely you'd get it right if you tried to Google that.
So if my team or a team on the call makes a decision that we want to put one of these things in place, maybe draft it up to the best of your ability, but run it by somebody who's probably going to be the one that defends you in court, just to poke holes through it and get it right before you put it in place.
Yeah, what's the point of doing it if you're not having it done correctly?
Right, good point.
I think we went through that. Here's another thing going back and forth, but one of the other things, Chip, and how you're good about this, you need to start training your managers and employees on discriminatory statements. Tom has trouble keeping up with the new computer system. Then we let Tom go. Tom's going to sue you for age discrimination.
Wow.
right? Well, because Tom had trouble keeping up with that new computer system. Sally's not very good at math. We let Sally go. Sally's going to sue you and say sex discrimination. You had this preconceived notion that women aren't good at, and we all know that's not the real reason you fired any of these people, but that's the claim they're going to be able to make if we don't have some sort of backstop on all these things and make sure we're very careful. Option C, horrible option for you, great for me, is there are some companies that just say, we're going to defend these at every cost. And you may have heard, soft tissue injury used to be a great way to make money. You get hurt, they would sue the auto insurer, the insurer should give them some money and make them go away. Finally, a couple of years ago, they said, look, we're going to defend every one of these tooth to the nail. We'll not pay a penny in settlement. And they've beaten it back so hard that people leave them alone. And that may be, it's a very expensive way to go, but that may be something that your company must do, is not get used to the habit of paying somebody $10,000 every time a lawyer sends a letter. Because if you do that too much, and I referenced Coca-Cola, they got to the point where everybody knew, just send a letter to Coke saying, I found something in the bottle. They'd send me a couple of cases of Coke. That got published in books and saying, hey, do you want a free case of Coke? Just write a letter. So that's something to think about.
Okay.
I'm going to go to the non-competition agreements. Classically, this was, and Arthur Murray was one of the ones most famous in Virginia for doing it. They would say, look, I've hired you, you know nothing about dance instruction. I'm going to teach you. I don't want you to go ahead and compete with me. They've now come back and said, hey, too many lawyers were doing this. So what we're going to say is you cannot require any low-wage employee to sign one of these. There's a $10,000 civil penalty if you do, and you're required to post a notice approved by the state concerning this act. You can use a non-competition agreement if they make more than, this will stun you, a low-wage employee is somebody that makes $59,000 a year. So if you make $59,125, you're no longer a low-wage employee. I think I can sign it. If you had one in effect prior to July 1st, you could still keep that in effect. Employees' earnings are derived primarily from sales commissions. Those people you can still use a covenant not to compete. I'm not going to go in detail over all these things, but those covenants still have to meet certain criteria. And again, if you do it on your own, the chance of you making it unenforceable is nil. Drafting points, my goal when we do them is I want to make sure that it's drafted so well that the other lawyer that looks at it says, hey, employee, abide by it. And the question I'd ask you is, if you're done with it, ask yourself if your son or daughter would sign it. If your son or daughter came to you and said, hey, is this an thing signed? And you say yes, that's a good sign that you've done a nice job drawing something narrow. Other strategies, and again, I try to have strategies where I can. Pipelines, a lot of people are salespeople in pipelines, to have a provision that says, if you leave my customers alone for a period of time, I'm going to pay you a decreasing share of commissions based on sales that come in after you leave on accounts that you solicited. Have an employee sign a non-solicitation agreement, basically saying, no, it's not a non-competition, it's a non-solicitation. It says, I'm not going to go knock on the doors of your clients.
Because a lot of people, they have an existing book of business. And is that where the non-solicitation is? So let's say I was an insurance broker working for Bank A, and now I'm an insurance broker working for Bank B, and I start ringing my old customers because I got their cell phones. We used to go to lunch once a month. I can't do that if I sign that non-solicitation, and that's okay.
Correct, yeah. And it may, well, I say this, it may be okay. Again, these are all brand spanking new laws.
Right.
But that's something we try to do. And then confidentiality agreement saying, hey, Chip, when you leave, I want you to take all those names off your cell phones. So this is the one I really wish I had a good answer for you. I got nothing. And if anybody has something here, I'd love you to put in a chat or a question to Chip and say, here's what I can do. Any employer with 5 or more employees during 20 or more weeks in a current or prior year must provide a reasonable accommodation to any applicant or employee who is experiencing pregnancy, childbirth, or a related medical condition. And then here's the list that's in the statute of accommodations. You know, the first couple, you're like, fine. Then you start getting to modifying equipment. Then you get temporary transfer to a less strenuous or hazardous position. Does that mean if somebody comes in and says, look, I'm pregnant, I've decided I don't want to do any of that lifting, make somebody else do it? In the old days, that actually was a violation for an employer to say to somebody, hey, you're pregnant, you can't lift things. That actually was against the law. That was sexual discrimination. Here under Virginia law, if they ask me for something, I've got to give it. They have assistance. Hey, there's some jobs that I really don't want to do. I want you to hire somebody to do my job. Restructure my job. Change my work schedule. You know, I think I need to take Fridays off because I'm pregnant in the summer. I don't know what you're going to do.
So I'm a roofing company, and all of my employees climb on ladders and carry shingles and use nail guns, and one of my employees got pregnant. At some point, it's a little difficult to climb a ladder when you're carrying a baby. But I don't have any desk jobs. I don't have an accounting position. I can train them. What do I do?
So good question. Leave, you have to give perhaps light duty or leave, depends on how you do it, or a modified work schedule. Come in an hour or two and answer the phone. But my bigger concern is this is what it doesn't say is, what if she says, I've tested pregnant today, I will be delivering in 6 months. I don't want to climb ladders anymore.
Ouch.
Yeah, what do you do? So that's the one where I just, if anybody has an idea, I can tell you what the law says is you have to work interactively. In other words, you can't come up with a similar rule. You just got to just talk to them and say, what do you want? You have to post information about their rights. You have to tell new employees about it when you hire them. Anytime an employee tells you that they're pregnant, you have to inform them of their rights. You have to include it in your handbook. And if you provide an accommodation to anybody else, there's a presumption that that accommodation is reasonable. So in other words, if somebody came into you, had a heart attack and said, look, I need 3 months off, and somebody else comes in there pregnant and say, look, I want the next 3 months off, I think you're required to do that.
So every accommodation you make, it's a precedent being set moving forward.
Correct. So to me, telework, for sure. They said, look, I want to work at home now. I don't know how you're going to get out of that. And then you have to reinstate them. So it's like the FMLA now being drug all the way down to people with 5 or more employees, which is, again.
Okay, let's go on. One of the questions I had coming into this,
Sure.
In the old days, we had a company handbook, and it's a piece of paper, and you can pick it up, and I can post crap at my restaurant in the crew area, and they can see it on the wall. In this new world that we live in, lots of my workers, we don't have paper, right? We everything I need to get, I can get from my cell phone. So is there any recommendations you have for company handbooks and notifications in a digital world with remote workers?
So I'm personally fine with doing it digitally, putting it on a website. The only thing I ask you to do is maintain version copies so that if somebody comes back to you and says, hey, he was employed 7 months ago, what did it say? You can't say, I don't know, we just save over the old.
Okay.
Certainly a best practice is have an electronic receipt, but I don't think that's required. You give a notice, you post it on my website. Very rarely do I ever hear anybody say that's not what the manual said or the policy said. I just don't hear that as a complaint.
Okay.
Let's go to retaliation. And here, this is pretty simple. There's just a host of things where if they do anything and you do something in response, you're going to get in trouble. So if I came to you and said, Chip, I really should have been considered an employee, not an independent contractor, you said, Barry, you're wrong. You're an independent contractor. And 2 months later, I say, I don't want to use, you say you don't want to use me anymore. I get to sue you and say, I should be, he retaliated against me by firing me because of that. There's certain exceptions, none of those are going to apply. If you came to me and said, I want you to sign a non-compete, and I brought an action and the court said, I'm setting it aside, you can't retaliate. The scary one is C, you can't retaliate against an employee who reports a violation of federal or state law to a supervisor or a governmental body or participates in any hearing. Okay, I kind of understand that. But 2, if an employee refuses to engage in a criminal act, and I say use your imagination, you'd be stunned at the thousands and tens of thousands of things that count as a criminal act. And this actually came in part because of a case a couple of years where a woman said her boss said, let's go sleep together. And she said no, and they didn't have enough employees to get under the federal act. So they sued in state court saying, he asked me to engage in a criminal activity. He was married. And the court at the time said, well, that's not a violation of Virginia law. It is now. So if you ask them to engage in a criminal and they refuse to engage in a criminal act, and I'm sure, Chip, your practice is highly regulated, it's going to be hard pressed for somebody not to say, oh, I said so-and-so, and that actually was a regulated act or a criminal act or a violation of some regulation. Same thing if the employee refuses to perform an order. And again, I don't expect that you'd ever fire anybody for this, but if they ever bring something up and then you do some termination in some short period thereafter, they're going to bring a claim of fact against you. In most cases, they have a right to sue for injunctive release, which means lost wages, benefits, attorney fees. I'm just pointing out it's not the crime, it's the cover up. You put somebody on a performance improvement plan, they protest, you then fire them, they're going to say, hey, look, even if I deserve the performance improvement plan, I complained about it, and you fired me because I complained about it. That's a violation. So my strategy here is be patient. Most of the times you have employees messing things up, they'll continue to mess it up, and they'll justify it. Obviously, Not obviously, but to me, if somebody files a complaint, fire off a response right away saying, thank you for bringing that complaint to my attention. We're going to investigate it. That is in violation of our policy to do so-and-so. And I want to remind you that no one in the company is allowed to retaliate because of so-and-so. And that way, if 2 or 3 months later, you have to let that person go, you can say, look, I wasn't upset about that at all. I was glad you brought it to my attention, but you just weren't a good employee. That's why we had to let you go. We're going back to questions, Chip.
Oh, well, we do have that other poll.
Okay, go ahead.
Okay, so let me go ahead and launch that. And there is a couple more questions I would really like to ask you if we've still got time. Okay, so we just put a poll up. Out of the people who you have discharged, I think basically in the past, what percentage of your workforce was because it just wasn't working out? And Barry, I guess you might want to clarify this, but it's basically when it was kind of vague while you were firing them, you didn't give them a specific, we caught you stealing from the register. Is that what you meant by this?
Correct. Yeah, it just wasn't working out. That's what you told the employee.
Right. Okay, we got 17 of the 38. Let's get a few more votes in here and look at it. We do. I can see it. We are looking at a clear winner, which you being the attorney don't like this answer, but you liked the answer on the 1099ers. So we got 25 out of 38. If anybody would like to participate, please do so in the next 10 seconds. 26 of 38. 28. Okay, and we do have a clear winner. I'm going to go ahead and end the polling and move along. Let's share the results. There we go. Look at that.
That's a good answer.
It's a very good answer. Yeah.
Very good answer.
So I guess HR departments have, and this is not that new. The penalties are new, but HR departments know we need to be specific. We need to, like, rate people up for the same thing 3 times and let them go. Don't do, oh, well, you smoked on the van and we caught you with no shoes on and, whatever, you're being mean, right? It's better to have 3 things.
The better part is doing that, though. A lot of people have said in the past, can I just let, and we did, I've worked with a couple of people in the last couple of days where we let somebody go for no cause. Hey, it's just not working out. You can't do that anymore. That actually is per se, you're going to lose because the jury has a right to say, what was your real reason? You didn't tell us what your reason was.
Yep. Okay, so we had something in the chat that's a one-off from what you're talking about, but again, going back to EO and all of the stuff that we're taught, company culture is extremely important. And so Michelle, which is our trainer here at SSBA, we legitimately kind of need to let people go if they're not a good fit, which what that really means is our company supports people with disabilities. We want happy, smiling people that actually care and almost love the individuals we support so that we can give them the best life possible. And if somebody comes in, they slip through the interview process, they seemed great, and then we find out they're acting like a security guard. They might as well be working in a prison because they're mean and combative and nasty. They're not a good fit. So what would you recommend Michelle say when she removes that from her vocabulary? When we have somebody that slips through and they are not a good culture match, how do we get rid of that person?
So 2 things. 1, be careful what you say to others about her. But as to her, I like those words you used. Is that, hey, we require that you be compassionate towards our clients. You were not compassionate towards our clients. You were mean, you were combative, you were whatever it is. Now, at the end of the day, obviously, I'm much happier if you have objective words than mean. Because when you say to somebody, you don't smile enough, they're like, what do you mean I don't smile enough? Or whatever
right.
it is.
But raising your voice?
Raising your voice. If you have, the more objective stuff you can put in that, the better.
Okay.
That's definitely what I want to have. Because again, in the end, you want to have somebody say, if you ever go in front of a jury, these are the reasons why. It wasn't because of their race, it wasn't sex, it wasn't creed, it was this. At least I got something to stand on, as opposed to say you weren't a good fit, which is just so nebulous. Yep.
Okay. I did have, as I was talking to Jennifer Fedora from BNPP, she was interested in the Virginia code section. I guess there's administrative code and then there's code of Virginia.
Correct.
Are you able to share those so that the HR departments can actually get the regulation in their hands?
So I'd love to, but none of these are regulations. They're actually statutes. They're all in the Virginia code. The ones we've all talked about are all in 40.1, and that's the title. 28.7:7 is one of them, I think :9. They're in the 28s, most of them in 40.1, 28. Or if you just send me an email, I'll send you the ones I have now. I can't send you all the ones that changed because there are about 1,500 laws that changed that went into effect as July 1st. And I pulled out the ones I thought were most significant. to you. But I can send you if you want the 4 or 5 that we've talked about, I can definitely get that list given to you. But none of those are administrative codes. These are all actual laws. And I'll end with this, that your legislators voted for. So if things turn out as poorly as I think they will for employers, you really need to go knock on these guys' doors and say, and I'll get on my soapbox for a minute, the things that they were trying to fight, I think were minuscule. I mean, very rarely do I ever really seriously hear somebody say they think somebody's fired because of their gender or anything like that. And what they've done is now basically allowed you, ambulance chasers would be a nicer word to put it, come after you, pirates, and hold you up on every single time you let somebody go. And so you want to go back to those legislators, do something to level the playing field. Let me get attorney's fees from them if they lose, because right now they have no downside of bringing a claim.
Gotcha. Okay, so we are at 2 o'clock. I do have a couple more very detailed questions that I think is going to be highly valuable to the audience. Do you have a hard stop, or can we go?
Go for it.
Okay, I'm not going to go down rabbit holes. I'm going to be quick, but I think that these are important. If currently, if somebody on this call realizes we might be misclassifying our 1099 employees and we need to move into moving them to W-2. I know you talked about like to put it in writing and things like that, but is there anything else to come into compliance with the new laws? Is there anything else you recommend for employers?
So again, to me, you have to go through and look at every single person, figure out where they fit on that spectrum of the test that we talked about. And the ones that are closest to employee, move to employee. The ones that you think you can move out, come up with a way to put them in, and then you'll have some people left over, and then it's a risk balance. What risk are you willing to accept? And
there's nothing I can do really to erase what's happened in the past.
Right, but good news is they're generally not going to go back. My assumption of the law is it's July 1st.
So if we have misclassified people, fix it now.
Fix it now.
Let's not talk about what we did in the past.
Okay, yeah, exactly. Good. We'll fix it by next pay period. Yeah.
Gotcha. Okay. Sooner. Okay. So we talked about that. There's another one. In the human services world, we deal with a lot of trade associations and EO. Many of the EO chapters have an executive director. Some chapters, some trade associations choose to hire that person as a W-2, and some do it as a 1099. Any suggestions on that, where an executive director only works for one organization, that's the only paid person they have? Same thing, just look down the list. And
we just go down that list. I'm going to pull it up and throw it on the screen so we're all looking at the same thing.
Because this, I guess these laws change that, right? What's happened in the past is one thing, but moving forward, each agency that has a 1099 needs to really think about this now.
You got to look at each one of those 1099s and then ask that first question, right of control. And I don't know enough about EO and how you act with your executive director, but does somebody tell them when they're supposed to come to work, when they're supposed to leave, or they set their own hours? If they're told when to come and when to go, that's a bad fact for you, right?
Yep.
Do they, financial control, if they have no investment in their tools, I'm sure, right?
Not laptop, cell phone.
Yeah, but that's nothing to speak of. They get paid an hourly rate most likely, or salary or something. They have no ability to make a profit, right? In other words, it's not like you're paying a little lump sum and they could subcontract the work out. And the work is expected to be of a long duration. Yeah, you're failing basically every one of these tests. Okay. Economic realities test, all their income comes from you. They don't look to somebody else. I like that you said some of the other rooms say, no, I do a couple hours here, a couple hours there, and it's up to me to make my determination to do that. You got a much better shot on those.
Gotcha. Either way, look at it and do the test.
Look at it, yeah.
Right. Okay. This is a tiny rabbit hole, but you didn't cover it. Me and you have talked about this a lot, which is overtime. And a lot of these new laws are about employees that say, I have not been fairly compensated. My employer ripped me off, right?
Correct.
But one of the things, as I have mentioned it in the EO community and the human service community, and they think I have two heads and came from Mars and me and Elon are best friends. But if I am taking an hourly worker, and maybe even a salary that is non-exempt, and I am bonusing based on their performance. For example, you turned in your work on time, I'm going to give you $100 a month, etc. I need to be, if that number is big enough, if it was $1 a month, it's probably not a big deal. Let's say it's $200 a month. If you show up and come to work on time, turn in your paperwork, I need to consider that $100 when I calculate their overtime.
Correct. Total pain in the neck, but you do. Now, there are two strategies to deal with that. One, obviously, is to try to set up their hours so that they're scheduled to work 37.5 hours a week. The theory being that it's highly unlikely during that month they would have worked overtime and you're probably going to be okay. On the other hand, if they're generally working overtime and going over 40, then absolutely you have to go back in and back it in and figure out what their rate was and then give them a premium on that rate.
Right. So in a situation like some companies went through the roof, right? And they might have thrown a lot of their employees into overtime.
Correct.
So example, if I do parking lot striping, a lot of companies are shut down, but they got PPP money, so whatever. So we're going to go stripe our parking lot because there's no traffic, right? The roads are empty, the parking lot's empty. So all of a sudden those employees go through overtime, and I'm going to bonus them because we're doing such a good job. I appreciate you guys. That those bonuses need to be factored in the overtime.
Correct. You have to go back in for how many hours they worked to overtime and give them a premium based on their regular rate to bring it back up.
And if I am not doing that with these new laws, I'm more likely for an attorney that knows this rule and knows that most employers aren't doing it. This would be one of those pirating things, which actually is legit. It's not pirating, right?
Yeah,
it's
no,
not
that's not
ambulance
pirating.
chasing.
That would be a legitimate claim.
This is legit.
That's a legitimate claim. But where things can get a little dicey is that what if that person who wasn't getting paid that overtime on their bonus was a subcontractor, somebody you were a subcontractor of, and this is in a construction project? Well, now you're cut under, you're the general, you're going to be liable for that as well. Because remember, if you knew or should have known they weren't getting paid, that thing, they can then bring a claim back against you.
That's multi-layered complexity.
Multi-layered complexity.
Oh my God. Okay, that's not good. Let me look. Okay, one other one, and this is regarding remote workers.
Okay.
Obviously, it's like they work from home. Like, how am I tracking their hours? If they're answering their cell phone after hours. So there's two really questions on this kind of remote workforce. One is, because we need to fairly compensate people or bad things happen now that we have attorneys that are pirating, is there additional things you suggest that employers do to track time to make sure that overtime is fairly compensated, et cetera? And then also when it comes down to employees who travel, for example, I have a division in Lynchburg, and I might send my QA person to Lynchburg to work for a couple of days to do training, QAs, et cetera, and she's going to stay in a hotel. So you got drive time, you got hotel. Is there anything that these laws have changed in regards to that? What my HR department should do to track and make sure the employees.
So the laws haven't changed. Your responsibility for them, they now may have a right to bring a claim in state court as opposed to just federal court, although they could have sued you in state court as well before. So in the Fair Labor Standards Act, you have to pay, as you know, for all hours worked. What I like to do, and my recommendation hasn't changed, get an employee to write back to you what their hours are if they're not in your office. And that way your position is going to be, if they ever come to you and say, look, I spent 10 minutes on a cell phone and you didn't compensate me for that, you're going to say, well, I paid you what you told me you did. And my instructions to you were to list all your time, including cell phone time. Travel time is a lot more complex, and it deals with, for the most part, the Department of Labor has said, last time I looked at it, it depends on whether it was during work hours or not work hours. So, and again, it gets very complex, but in an overnight situation, if I am traveling during work hours, that is compensable time. If I'm traveling outside my normal hours of work, it isn't compensable time. Conversely, if it's during the day, if I report to one place of work and then I go to another house, all that's going to be compensable time. But those laws have not changed.
And if I had a break of 4 hours between two houses and I was able to go shopping and pick up a couple items,
then yeah, that's not work time worked. Correct.
Yep. Okay, and when you were talking about workers turning in their time, obviously hourly workers typically clock in, clock out. Not worried about them. I think
except on telework now, because telework they may not be clocking, right, as you pointed out.
So an hourly employee either would, if they're not clocking in and out,
right,
then they're going to track their time themselves, and they're either going to turn into the HR department like the number of hours worked each day, or even the week. I believe you said it was okay to say I worked 38 this week and 42 that week. Employer has to pay overtime on the two.
Correct.
But it can be just one number. It doesn't have to be per day. It doesn't have to be time in, time out. As long as they're attesting that this is what I worked and the employer compensates them on that, liability is not on me.
Correct. And I'll go out on a limb here and say in Virginia, because I believe in California, if you work more than 8 hours, that's an overtime premium for that day. Virginia has not gotten there yet. Okay. But yeah, in Virginia, it's a federal law, and Virginia hasn't changed it, though. That will have a minimum wage, which goes into effect next year. I didn't put that in here. But again, track it by the week.
And I am almost done. Almost done. I think this is my last question. I do not see any questions in the Q&A, and then we'll do our goodbyes. Okay. You mentioned earlier, I think it was a demand letter, but basically my question is, what are the first few steps a company does, if they get something from an attorney, from either a pirate or an ambulance chaser, what do I do? What do I direct my HR department to do?
Okay, so my very first question is going to be, when I get the first one, call your insurance broker and say, do I have coverage? If you have some sort of coverage and you go try to handle it yourself, the coverage goes away. So yeah, if you have insurance and you try to play with it, that in every insurance policy says that then takes away the insurance policy. It's like it never existed.
Okay.
So let's not do that. So if the broker calls you back and says, no, you didn't have that extra policy, then, what's the demand? And you've got to make a determination. Is it a demand for $500 and you can pay somebody and be done with it? And that's what I talk about. It might just be the cost of doing business. If it's significant and you have a lot of employees and a lot of turnover, you may want to talk to a lawyer to say, do I have to start defending these? What am I going to do? Because this may not be the last. And I will say this, it's not uncommon that we have one of these now where an employee brought a claim and said, you weren't properly paying me the way I was clocking in and clocking out. We settled with him. Well, within 2 days, employee number 2, his friend called up. And then 2 days later, employee number 3 called up. So once you start we call it putting blood in the water, the sharks will continue to circle.
It's probably safe to assume anything I respond could be held against me in court.
Oh, unquestionably.
Unquestionable. So assume the phone call is being recorded?
Yeah, I would assume that.
Yeah.
But again, they don't really care because in most of these pirate things, all they want to do is go in front of a jury.
Gotcha.
And if a jury lights you up for $1 million, great for them. If they get nothing, we'll just go to the next one. Or
I heard a couple different thresholds there. Let's say $500. It's not worth getting an attorney involved.
Oh, yeah, no.
Don't even try it. If it's $10,000, it might be worth calling your attorney and paying for an hour or two of some brain power to say, how do I handle this?
Oh, it's definitely worth it at $10,000 because otherwise it's going to be 10,000 times the next 4 or 5 employees you get rid of.
And then if it's $200,000 and there's 6 employees on a class action, get your attorney now, keep your mouth shut, and let them handle it. Is that fair?
Yep. Yeah, they are not trying to resolve. I have not yet met a pirate that's trying to make your business do better. They're just trying to separate you for some money. And sometimes you can make a little bit of money and they'll go away, and sometimes you can't.
Okay. I'm pretty sure you answered all my questions. Amazingly, the Q&A box is empty.
Fantastic.
So I think we're good to go. Barry, once again, I really, really appreciate you taking the time to do this. If you don't mind, let me do a quick screen share. And for people who want to get the slides, it's going to take me a minute to render the video. But this is, we got 2 different places we put things. The EO chapter, I'm now the communications chair, so I've been working hard to get these webinars posted to our YouTube page. So they're open to the public. You can share it with your HR departments, other company, business owners, et cetera, anybody that missed the call. This is where I've been putting these webinars. The keywords are probably going to be the title of this webinar, but you can also see where Barry took us through the Paycheck Protection Program and some other of our strategic alliance partners that have done these type of educational webinars. We are also, I would definitely say subscribe to this channel. It is brand new, so we only have 4. But subscribe to the channel. I guarantee the stuff we're putting on here is directly applicable to businesses, owners, but nonprofits. Basically, it's all the same thing. It doesn't matter.
Chip, are you going to send out that link?
Yeah, I can. That's fine. I can't. I'm sorry. That's why I'm doing this, because I don't believe I have the contact information for the people who have attended.
Okay.
Oh, okay. What I can do is I can copy this and put it in the chat. If I can find the chat. Let me find the chat. But the other thing is the chat does not portray in the video. I, of course, cannot find the chat anywhere. Let's see. Crud. Okay. Okay. Once I stop sharing, I'll put it in the chat. Okay. Here's the YouTube page. We also have a Facebook page that's quite active, talking about what's going on. So usually it goes to YouTube first, and then we throw it over to Facebook. And so for the handful of people that still use Facebook, maybe like our EO Southeastern Virginia Facebook page, and you'll get updates as we load these webinars on there. So that's where you can find it moving forward. So I'm going to stop sharing. I need to move our heads out of the way. Of course, Wolcott Rivers and Gates has a website. If you want to get more information from Barry, you can find him under our attorneys. He's the one that's the Jedi Master, Barry Dorns, right down here. I will put their website, and I can see you shaking your head. Thank you, Barry. This has been amazing. I learned a lot, even though I already knew the answers to a lot of questions. I always learn a lot every time you open your mouth.
Chip, always a lot of fun with you and your group, and keep EO going.
All right. Thanks a lot. We'll see you next time.
Have a nice one.